Okay, this is the countdown. So I think first and foremost, Chris, we need to figure out a name for this podcast. Got any good names for this thing? It can't have the words trade secret in it.
I don't know, tangible podcast. Make it
The tangible podcast.
tangible.
Make it tangible.
Reasonably tangible. Kind of riff on the whole reasonable measures.
It sounds like
reasonable measures podcast.
Oh, there you go.
You get there.
Keep it reasonable.
Be reasonable.
That's interesting. Maybe it's also worth bringing some marketing resources into
smarter people than
this
us.
process. Certainly than me. Okay. So look, the reason why I wanted to take a stab at doing these sort of short form podcasts, everybody does long form. I want to do short form. And some of this sort of is a result of our, now, what is it, 12 years of knowing each other and working together in one form or another. And for me, it's always been really interesting to be able to sort of ask you any really stupid question when it comes to IP and have you be very patient and give me an answer. And so I thought there's so much unknown and misunderstanding around this whole trade secret space. I thought it'd be super fun to launch something that's also a little bit educational, but again, keep it a little bit fun and sort of topical. So the thought here is to do one case law review and then sort of chat about some stuff going on in the market currently. So anyway, nice work today on the IHC webinar with Nicole at DLA. That was really cool. And so, okay, with that, let's jump in to our case. Today's case is a decision from the U.S. District Court, Seattle, February 12th, 2024, so very recent. Plintron Technologies USA versus a whole handful of people as the defendants. These are former executives. And I think, part of today's sort of theme is all roads lead to India. You just back from India a few weeks ago, which we'll talk about. But Plintron Technologies USA LLC is the U.S. subsidiary of a Indian-based technology company. I think do some sort of telecom related something or other. And so I was sort of drawn to this case for a few reasons, not the least of which was this idea of sort of establishing like likelihood of success in a case. And so, and then the deeper you go into the case, sort of the more silly it gets and sort of interesting. And so maybe as the setup, maybe you could just kind of give us a little bit of an overview of the case, talk about this likelihood of success sort of hurdle or threshold, and then we'll kind of dig into a few of the details.
Sure, Tim, that's a great intro. And this case is actually still ongoing, so it's very much still in flight. And what the court was deciding was just the plaintiff's request for a temporary restraining order. So it's one very narrow question, and it's very much a procedural issue. And it reminds me of law school. My very first class and very first professor was famous or infamous for saying that procedure is everything and substance is nothing. And he had a very strong view that, everyone got excited about the substance of litigation, but it's actually procedure and doing procedure correctly that ultimately wins the day. And this is a good example here where there were a bunch of executives who either left the company or were terminated. It's not entirely clear, who was let go and who left of their own. But there's a question around basically a laptop computer that one of the executives wanted some personal information to be deleted from the laptop before returning the laptop to the ex-employer, because it was a company laptop, not his personal one. So I could speculate as to what's on the laptop, and you could be really creative in coming up with wild ideas of what's so important on that laptop. But the court doesn't really say here. But a temporary restraining order is actually really hard to get. You have to jump through a lot of hoops and satisfy. They're called winter factors. It's not the time of year. It's actually named after a guy who was Secretary of the Navy in another lawsuit. But it's really, really hard to get a temporary restraining order. You need to be in a position of having a very high likelihood of success at the litigation. And especially you need to be able to show irreparable harm or irreparable injury. Basically, things have to be so bad or so precarious that if the court doesn't issue this TRO, you're going to be harmed incredibly. And what the court did here in looking at the various winter factors is basically said, this is nowhere near a super compelling situation. Like, the executives haven't started their own competing firm. They haven't gone to a competing company, at least not yet. And the big issue is around this one laptop. So it basically fails the factors that go into this winter test. And again, procedurally, they just denied the request for a TRO, but the litigation will still go ahead. So I'd say this is a very small win for the defendants and a very small loss for the plaintiff, but the litigation will still go forward, and certainly worth watching. But to me,
And
it's
is
more of a procedural thing that makes it interesting versus good substance or bad substance.
so a couple of things. Well, I think it's a good lesson for all of us in commingling, personal stuff on work stuff. And I would say, boy, I'm not sure there's anybody that doesn't do that at this point. And so that I found kind of interesting. You know, Look, if you just look at this case, you sort of see like, yeah, they haven't talked about any specific trade secrets, right? Any really specific anything. And so it is pretty weak, right, on the surface. And obviously that, kind of comes out in the decision. I mean, do you file something like this just as a sort of a way to say, just give us the laptop back? Is that what's actually going on here? Like, is this trying to force the laptop issue? Because, basically what it's saying is, the executive in question is saying, look, I don't want to give you the laptop back yet because it still has my personal stuff. Now, I'm happy to give it to a third party and have them parse personal from business, but I'm not just going to hand you the laptop back. And so I kind of wonder, like, I don't know. It looked like this case was kind of doomed from the beginning, and so. But do you almost have to file it? Is this like almost a
Well,
requirement?
it's very common first step for a plaintiff. So, like in litigation, there's a lot of steps, and most of them are kind of like you just do it, even if it's optional. You do it anyways. So, as a plaintiff, you often ask for a TRO right out of the gate, and admittedly, this one it's kind of weak. Like there's not a whole lot of compelling urgency to this request. Uh, Also, like for a defendant, the first thing that they do is ask for a summary judgment. Like basically say the plaintiff hasn't satisfied what they need to do for the case to go forward. So my guess is that will be the next thing to happen. Is the defendants will try to get summary judgment, but we'll have to see. But again, that would be a very normal chain of events. And maybe there's some more detail behind what the trade secrets actually are that are just not showing up. But
Yeah,
at least so
yeah.
far, it seems pretty thin.
And so, one more point of speculation is if if this group of executives had already started another company, let's just say, this would look very different, would it not, in terms of irreparable injury?
Yeah,
Um,
totally. And the two most common scenarios that we keep seeing over and over is a departing employee goes to a competitor and takes a lot of information with them,
yeah,
or they start their own competing shop and take a lot of information with them. And at least in this first document, it's not really clear that either one of those has happened yet. So yeah, it would be a lot different
right.
if if the facts were more normal. I mean, again, to me, this is not a super compelling situation, and that's why the TRO was denied.
Yeah. Okay. Cool. Thank you. That was great. And I think as we get deeper into our own case law reviews, it's yeah, it is there is no lack of procedure and steps in these cases. Uh, so talk about India. So you went to India as part of our partnership with Wipro. So Wipro is a massive company and is a tangibly investor. And so you were there, a few weeks ago to kind of get the wheels turning with our partnership. And I haven't been to India since probably 2012, 13 maybe. And so it's been quite some time. So first, I'm just super curious of boots on the ground, like what's going on in India these days, and where were you? And anything you tell me and us will be interesting. So love to hear about the trip.
Absolutely. So I spent about a week and a half in India in February, so a month or two ago, and
Okay, it's been a little
time
while. Yeah,
flies tangibly. And
yeah,
yeah, it was initially meant to visit Wipro. So I visited their facilities both in Bangalore and in Pune. But then I also gave seminars at three law schools in Pune and had just a great experience and great conversations with up and coming lawyers in India. And it was really interesting because I got a lot of super creative, unusual questions, but all students at all three law schools all asked the same question, which is when will India have their own trade secret statute? Because India currently does not have anything. And if you have a trade secret stolen in India, you have to kind of creatively patch together a few other causes of action. There's no specific statute like there is in
yeah.
US or Europe or China or Japan. Uh, and in all three law schools, I said the same thing, which is I think India will get there, but you have to be patient. It'll probably be 5 years, maybe 10 years, maybe longer before you have a trade secret specific statute. And I was wrong. So it was kind of shocking. But on March 5th, so a week or two after I left, the Law Commission, which is a government created body that they're not a government agency, but they're extremely persuasive in directing the legal system in India, came out with a 180-page report talking about how critical trade secrets are for Indian companies. And they even
I love it.
drafted like a sample statute for the Indian government to consider. So I wasn't wrong. Just my timing was way off.
Yeah. That's amazing. Yeah, usually it goes the other way. Predictions are usually way ahead of themselves. So that's amazing. Well, it'd be interesting to see, as we've done a lot of work looking at how these laws differ, from one jurisdiction to the next. I think at the core, procedurally, they're often different and have sort of nuances, but at the core, they all sort of feel pretty much the
And
same,
it's kind
which I think has been kind
Oh,
of
I
an
was to
itch.
say it's kind
Yeah,
of interesting that the
yeah,
pressure to improve the legal system or to create new statutes actually comes from home. So, we've seen the same thing in China and now with India, that it's the local companies that are putting pressure on government. So it's not foreign companies or multinational companies that are international. I mean, they have some influence, but it's actually the local companies that are saying this type of protection is important to our success. And it's actually needed by Indian corporations. And that's where the pressure is coming from. It's not coming from US or Europe or overseas.
It's awesome. What was your favorite food? What'd you like? You hadn't been there in a little while either,
Yeah,
right?
I hadn't
Been a
been
few
there
years
since
since you were
before
there.
COVID. So, it was really just getting back to all the spicy foods and interesting foods that I have loved from previous trips. I had, and it's funny, there's kind of a interesting correlation where the cheaper the food, the better it tastes. And
Totally.
but I had a great trip, met a lot of really good people, and they're excited about the future of trade secrets and working with Tangibly.
Fantastic. Well, here's hoping to the data on that guy's computer gets parsed. They get their computer back, and it ends happily ever after. So
Yeah, I think it will.
good first version.
Awesome.
Yeah. Thanks, Chris.
Okay.
Awesome, man.
Thanks, Tim.
Later. We believe trade secrets are the largest and most valuable asset class in the enterprise, and they deserve their own systems. And that's why we built Tangibly. Tangibly is a platform to help companies identify and protect trade secrets. Platform's end-to-end solution includes our proprietary AI that was designed to analyze patents and predict underlying trade secrets. Tangibly is used by companies large and small, as well as by law firms. Our investors include Madrona, as well as DLA Piper and Wilson Sonsini. Thanks for listening, and see you on the next episode.